What if I told you that most people agree to contracts that were never enforceable to begin with? And what if I told you that the one thing that makes the contract binding is the simple fact of lawful consideration? That is the thing that nobody understands. Lawful consideration is the core requirement. So this will be episode 3 of my 5-part series. Every enforceable contract in modern law rests on this one pillar. Not signatures, not notarizations, and not stamps or seals. Value. If a contract has no lawful consideration, guess what? It is void, voidable, or even unenforceable. Unenforceable in the sense of nullifying the obligation, because if somebody says you are obligated to pay something and there is no value exchange, then guess what? It is unenforceable. So we're going to actually talk about what lawful consideration is and how to challenge it the right way. Make sure you stick around all the way to the end, because we're going to dive into something that nobody is talking about. Remember, this is not legal advice. This is not financial advice. Remember to do your due diligence. Remember to do your own research. Remember to look this up on your own. All right? I take no responsibility. All my rights are reserved. This is your fight. Number 2, hit the like button, hit the subscribe button, tap into the channel. Tap into the channel on a consistent basis, because if you do that, guess what? You'll get more and more comfortable with the knowledge, more and more comfortable with the information. All right? So thank y'all for watching the video. Let's dive into another one. So one of the first things I want to just break down is what lawful consideration really means. Now, I did a video yesterday. I actually posted 2 videos yesterday where it was the first 2 parts of my lawful consideration series where I'm breaking down the truth, breaking down the element of lawful consideration. I did a whole video on this, but to pretty much recap on what I said in the first video, you can forget those internet definitions, forget the conspiracy versions. Let's start with the actual law, okay? So if I were to go to, and this is what I pulled up, which is the Restatement Second of Contracts, Section 71. In the Restatement Second of Contracts, Section 1, you feel me? You can go ahead and you can find this information online, all right? So this is not coming out of my ass, all right? It's something that's online, and this is what I suggest you to do, is look this up, okay? It means a performance or return promise that must be bargained for. A performance must consist of an act, a forbearance, creation, modification, destruction of a legal relationship. This means that both sides must exchange something of real value, not illusions, not expectations, and not bookkeeping entries, which is our argument when we are challenging lawful consideration. Now, when it comes to the economic truth and the legal truth, they coexist, because the simple fact that we can easily say that the banks are not giving real value. But when we truly break it down, how the courts are going to see credit creation, they're going to see credit creation as lawful consideration. Now, let's just break it down. Putting that up front so you don't get excited, click off this video and say, I'm going to tap into law consideration, is so that you can watch this video all the way through, so that you can get the full scope of it. But this right here pretty much explains that it must have real value. It must be tangible. It must be real, okay? It must be clear and conspicuous, all right? Not only is the value one thing, but also the performance. Because when you purchase a home, the performance that you think that they only have to offer is the home, okay? Them giving you the home and you performing by paying over time. But the reality is that they are a servicer. All right. And if you challenge the contract itself and they fail to provide documentation, they are not doing or performing on that contract. So the consideration falls. Now, if we go to Restatement of Contracts and then we go to Section 79, when we go to the Restatement, Section 79, it talks about the adequacy of consideration. OK, now in this section, it pretty much breaks down how the courts, how to properly what will be adequate when it comes to consideration, okay? It explains that the courts do not weigh value, but they do make sure that consideration exists, and they will have to essentially prove it. All right. So the courts don't really compare who gave more, but they do check to see if anything is given. All right. And that's pretty much breaks down this entire section. It's broken down. You read this all the way through. But the reality is this right here is going to tell you what would be considered consideration. Okay. They even break it down to say, A contracts to sell property to B as a favor to B, who is C's friend. So they give you different scenarios, and this is how detailed the law is. Okay. But to break this down, it pretty much explains what a actual exchange is, and essentially, what a bargain is and what would be an equal value. All right. So let's go ahead and transition. I want to transition by talking about the Fund Yourself Academy, because if this is finally helping consideration make sense, breaking down and understanding the value of consideration, that's exactly why I built the Fund Yourself Academy. So that one can be able to not only continue education, because I continue to make YouTube videos, but to expand their education with resources, right? With the blueprint to be able to delete collections and charge-offs, how to be able to build your credit, right? The events, monthly calls, right? The whole aspect of the Fund Yourself Academy is so that you can connect with the community, get resources, classes, and templates so that you can be able to continue your education when it comes to consumer law. I don't teach theory. I teach structure. I teach the UCC. I teach contracts, documentation, strategy, the exact path to operate with clarity, not confusion. So if you're ready to move from learning to building, the link is in the description. Tap into the Fund Yourself Academy. It's only $27 a month. All right. So let's just switch gear and get back on track. The courts simply don't care about opinions. Okay. They focus on a simple test. Question number 1. Was value given? Money, goods, services, rights, performance. Let me repeat that. All right. Money, goods, services, rights, performance. Okay. So when I'm talking about this, money, goods, services, rights, and performance, it doesn't just fall under money and goods. The value also requires the services that they are going to render. It also requires them to honor your rights. And if your rights aren't being honored, that is also consideration, value lost, and then performance. If you ask them to send you a letter, you are validating debt, you are asking for a disclosure, and they fail to provide that, that is a failure of a performance on the contract, which then loses its value. The other question that you would ask when it comes to lawful consideration was it bargained for? Okay? Meaning, did both sides agree to the exchange? And was it exchanged? Not a promise, not implied, an actual exchange. That's what consideration is. And if any of these are missing, lawful consideration fails, and the contract loses enforceability. So then the question is, well, if we understand this, right, does the bank meet this legal test when it comes to the question? Question number 1, did the bank give value? Economically, no. That's the truth. That's just the reality of it. All right. You and I both know that the bank is not really giving lawful consideration, especially when it comes to the value, money, you know what I mean? The fact that you are creating the asset and they are creating a mere liability. But legally, the system treats it as a yes. And when I say the system, I'm talking about the court. Okay. Economically, there is no value, but how the court is going to see it, because remember, it's literally just a show. Right? It's a game. And whoever can paint the best narrative will win. It doesn't matter whether you are guilty or not. So the first thing that you have to understand is what I talked about in my last video is where to find this in the UCC. Okay, value and consideration, 3-303. It essentially says that it says an instrument is issued or transferred for value if the instrument is issued or transferred for a promise of performance to the extent the promise has been performed. The transferee acquires a security interest or other lien in the instrument other than the lien obtained by a judicial proceeding. The instrument is issued or transferred as payment of or as security for or antecedent claim against any person, whether or not the claim is due. Transfer or in exchange for a negotiable instrument. Transfer in exchange for incurring of a irrevocable obligation, a third party by a person taking the instrument. Long story short, a value can be performance. A value can be a delivery. Value can be an acquisition of a security interest. The banks rely on the third category, which is not money, but security interest plus bookkeeping entries. This is where it gets tricky. Okay? The acquisition of a security interest is almost like they are acquiring it for you. Okay? At least that's how I see it. The next test, which will be the next question, was it bargained for? The contracts will say yes, it was bargained for. You did agree to, them to acquire security interest, service it, and basically, make more money off of all of this. But here's where, even though you may say yes, the contract may say that you agree. The question was the fact that you wasn't even told the whole truth. When you signed the contract, nobody told you that they was going to make more money off of this. They just make it seem like they wasn't going to record this as an asset and basically reverse it back to you and still make money off of it while you still pay it. Didn't even mention the fact that the Federal Reserve is going to clear the money for them. So the fact that you wasn't told the whole truth is a lack of disclosure, which technically can fall under the category of losing that consideration. The next question is, was there an exchange? Yes, there was an exchange, but it wasn't what you think. Okay? When I break it down, the borrower signs a negotiable instrument. The bank deposits that instrument. That deposit becomes a loan. And when that deposit becomes a loan, that they then record that as their asset. So you funded the loan, but legally the system recognizes their credit structure. This is where the dual truth shows up again. The fact that you funded the loan, but the system or the courts is going to recognize it as they're the ones, simply because they have the structure. Okay? Now one may look at this and get discouraged. Don't get discouraged. Even though I'm giving you guys this truth, the point of this truth is the fact that if you just take simple steps, they're not going to be able to provide certain documentation that is going to essentially incriminate themselves. Obviously, the deeper you go, the bigger the debt, the more they're going to fight. But if you're dealing with collections, charge-offs, right? Debt that is zombie debt that is no longer, attached to you, to a company that is no longer servicing you. This is when these strategies become, very helpful. It gets hard when you try to use these strategies or try to use an equitable strategy towards an account you want to keep open. Okay? It's possible that the account can stay open, but you have to, if you do decide to go this route, you have to run the risk of losing your account. All right? Because it's not about keeping the account. It's about getting rid of the debt, discharging the debt so that you can start to build. And if they close that bank account, just open another bank account. As long as it's not on your credit report, you should be able to open up another bank. You should be able to get funding from anybody else. But some people don't look at it that way. So when you take them through that test, just to get back on track, number one, yes, they know they didn't give value economically, but they're going to treat it as a yes. All right. They're going to use security. The fact that they are essentially acquired security interests, or that they have security interests, for the reason to prove that they have given value. The other question when it comes to lawful consideration is, when you guys bargained, right? Yes, the contract may say that you agreed, but the contract must be clear and conspicuous, have full disclosure, have mutual assent, a meeting of the minds, in order for someone to essentially have adequate consideration. And then the truth behind things is the fact that there is an exchange, but it's not an exchange that you think. They make it seem like you signed a loan agreement, a contract to pay them back money that they risk. And you are under the assumption that they are risking their own money, which essentially is not true. So this is where you have the ability to challenge the lawful consideration. You have the ability to take a look at what they have going on and use it against them. You could put out the fact that, hey, look, I'm not trying to, bring out the fact, expose the truth about credit creation. But what I am trying to say is that, boom, there was something about my contract that wasn't fully disclosed to me. Okay. And I had to go find out that information after the fact. And when I found out that information, I realized that you were continuing to do things. And I started to ask for disclosures. I started to see what my loan was about. And the reality is that you never gave me that information. So regardless if you gave me the information, whether if you are truly who you say you are and you are moving in good faith, then it should be easy for you to produce documents. If you're moving in good faith, it should have been easy for you to tell me exactly what the contract was about. And in my last video, I talked about the importance of good faith when it comes to contract law. Okay? Someone can make it seem like, oh yes, this is a contract you agreed to pay. But if they created a contract in bad faith, then that also becomes null and void. But you have to be able to prove that they are not moving in good faith. And how do you do that? By you moving in good faith, you doing your part, and you showing them that, and you proving and showing how they move. Because if you are doing your part, there's no way that they can say that you are not performing. It's only when they stop performing. I hope y'all gathered that. So now that we kind of talked about that, let's actually transition on how to challenge consideration. Okay? I want to be very clear to you. You do not challenge consideration by accusing fraud. You challenge it by demanding proof of value under law. Okay? So here are the real points. You request proof of lawful consideration under Restatement Section 71, under UCC 3-603, okay? Under the Truth in Lending Act 15 U.S.C. 1631, 15 U.S.C. 1632, okay? Get comfortable with these laws because these laws lay the foundation of the legal merit behind you being able to use this in your argument, especially if you're going to use this. Get comfortable with this information, the disclosure requirements, the duty of the creditor, okay? The question you want to ask is, show the actual value that formed this obligation, which is a valid question to ask. Other ways to use the UCC when it pertains to challenging the consideration is demand the chain of title or demand the chain of value, not the chain of title. Under UCC 3-201, it explains what negotiation means. It means the transfer of possession, whether voluntary or involuntary, of an instrument by a person other than a leaser, or other than the issuer, to a person who thereby becomes the holder, except for negotiation by a remitter. If an instrument is payable to an identified person, negotiation requires a transfer of possession of the instrument. Okay? And then UCC 3-203 talks about the transfer of an instrument and the rights acquired by transfer. So the question that you can essentially ask is, who risked that, who delivered that, and when did they do it? When did they do it? You can then, not only can you demand the chain of value, but you can also force the truth in lending disclosure of the true lender. The Truth in Lending Act pretty much the whole purpose of the Truth in Lending Act when it comes to lending. The Truth in Lending Act is put in place for the purpose to assure a meaningful disclosure of credit terms so that a consumer may be able to compare more readily for the various credit terms available to him and avoid the uninformed use of credit. So again, you cannot uninform me when it comes to credit. Under 15 U.S.C. 1601, I can go back, okay? And then I can go to the restatements. Because under the Truth in Lending Act, the creditor must disclose the truth, okay? Then in the restatements, essentially talks about illusory or alternative promises, meaning any promise that is apparently an illusion, which is everything that we just talked about. If you believe that the lender's value was an accounting trick, that's when you can essentially raise the question about, this would be your reasons behind even asking, okay? The fact that they even have a restatement section, which is a legal doctrine that talks about illusionary practices, promises, so you can challenge that there, okay? And when you tie it all together under UCC 3-305, you can assert your defenses against claims in recoupment. If somebody essentially has a claim on you, you can essentially challenge them and ensure, especially if they cannot prove that they are the holder in due course. If they're able to provide a holder in due course proof, this is a valid defense against a negotiable instrument. Okay? These are all the laws that you essentially want to be able to get comfortable with. Okay? Down to the restatements, down to 15 U.S.C. 1601, the Truth in Lending Act, down to UCC 3-203 and 3-201, down to UCC 3-303, okay? Down to UCC 3- down to the Restatement Second of Contract, Section 79, okay? Down to the Element of Consideration 76, okay? Get comfortable with the information. The laws are right here. The more that you review these, the more that you kind of take a look at this information, you want to be able to cultivate a letter. You want to be able to cultivate a response. You want to be able to know what to do next. It's literally here in law. Now, here's why most people fail when challenging lawful consideration. Most people fail because they challenge with the wrong truth. They scream fraud, scam, no real money. They use the straw man theory, etc. And instantly the court will shut that down. The thing is that, the reality is that, yes, I'm going to keep bringing up the fact that it is the truth, the straw man and all of that. That's economic truth, but you're not going to go in there to fight the court about that. Okay? You must challenge the real legal truth, not the emotional truth. The winning approach is to use these statutes that I'm talking about. When you pull up the statute to where they violated you, it's only a matter of, why did you do that? You didn't even have a place to do that. Whether the person, you believe this person is supposed to pay you, you didn't have a place to violate their rights, okay? The restatement rules, the UCC, asking for proofs, okay? Force, the fact that they should provide documentation, because remember, documentation also falls under the category of lawful consideration because that would be considered performance, okay? And also at the same time, in order for something to be adequate consideration, it must be mutual assent. In order for you to say that what you have was your consideration, I would have agreed to just credit extension. It should, in that contract itself, it should say that this is a credit extension, okay? This should say that we are going to securitize it and make money, okay? This is what it should say, but it didn't. I'm not trying to debate whether or not y'all should be doing that or not. I'm just debating whether I should be paying it. And if if you guys got the value up front or not, okay? Keep your emotions out. Stay stoic when it comes to these processes, when it comes to anything, all right? And then make sure your structure is tight. Make sure you have your documentation. Make sure you're putting together an evidence binder when you are getting your documentation, your letters, putting your things together, okay? Now, the one case that I want to pretty much highlight to you guys is this one case. I'm not going to go through this whole case, and you guys can go look this up, but Antonio de la Cruz versus City Mortgage, Inc. To break this down in layman's terms, the borrowers challenged whether value was actually given after securitization and chain breaks. The courts didn't end up giving them the win, unfortunately, but they acknowledged the legal issue being legitimate. If you attack the structure and not the system itself, you actually have a position to win. This is how you truly become sovereign. This is the lesson behind it, okay? You win through structure and documentation, not rebellion, okay? Here's how you apply this in real life. Debt discharge battles. Challenge consideration under UCC 3-303, the restatement section 71, UCC 3-305, where you can defend yourself, and use the Truth in Lending Act to be able to challenge for the disclosures, to have them provide those disclosures, proof of claims. You also want to request proof of value given at origination, especially when it comes to credit agreements. When it comes to contracts in business, I get a lot of questions about when people do contracts of business. You must understand and know when a contract is enforceable or voidable, okay? Entity and trust structuring. Use proper agreements to create real consideration internally, okay? When you have an entity and a trust, you are able to create some legal distance from you and the business or the entity. So now if you now assign your debt to the trust, assign your debt to your entity, now it's out of your personal name, and now the entity can handle it. However, you're still responsible for it. It just will be out your name, right? You don't win by screaming the truth. You win by proving the truth the system recognizes. So in episode 4, we're gonna break down the biggest trap, why most consideration challenges fail, and how to build a challenge courts must respond to. And if you're ready for the full structure, join the Fund Yourself Academy on School. Now, you guys want to make sure to hit the like button, hit the subscribe button, tap into the channel. Make sure to turn on those post notifications, because if you think about it, making sure that you create a challenge that the courts must respond to is super important. You have to get full clarity of this. Okay, I want to say, well, why don't you put this all in one video? Well, I did a whole video on consideration, but this is why I'm breaking it down in parts so that you can go to whatever video you feel like fits your situation. Okay, however, the best case scenario, watch this all the way through. Thank y'all for watching the video. I love y'all. And if you gotten this far, comment the word fund yourself, and I'll see you in the next one.